The Indian Contract Act Consideration. Hello dear students, the topic that we are going to study today is Indian Contract Act Consideration. Let us study what Indian Contract Act is before we study the term consideration. To begin with, any commercial activity that requires understanding among people concerned. This understanding is often reduced into writing to give effect to the intention of the parties. Such formal versions are known as contracts. These contracts define the rights and the obligations of various parties concerned to facilitate easy performance of the contractual obligations. The law relating to contracts in India is contained in Indian Contract Act 1872. The Act was passed by British India and is based on the principles of English common law. It is applicable to all the states of India except the state of Jammu and Kashmir. It determines the circumstances in which promises made by the parties to a contract shall be legally binding on them. All of us enter into a number of contracts every day, knowingly or unknowingly. Each contract creates some rights and duties on the contracting parties. Hence, this legislation, Indian Contract Act of the year 1872, being of skeletal nature, deals with the enforcement of these rights and duties on the parties in India. Now, let us study the term contract and few other terms that help us define the term contract. What is a contract? While all contracts are agreements, all agreements are not contracts. An agreement which is legally enforceable alone is a contract. Agreements which are not legally enforceable are not contracts but remain as void agreements which are not enforceable at all, or as voidable agreements which are enforceable by only one of the parties to the agreement. This observation would raise a question in our minds as to what is the exact meaning of the words agreements and the word contract. An agreement is a promise or a commitment or set of reciprocal promises or commitments. An agreement involves an offer or proposal by one person and acceptance of such offer or proposal by another person. If the agreement is capable of being enforced by the law, then it will be a contract. Now, let us take a look at the definitions as per the Act. Section 2B, while defining a promise, provides that when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. Proposal, when accepted, becomes a promise. Section 2E of the Act defines an agreement as every promise and every set of promises forming consideration for each other. Section 2H of the Act defines the term contract as an agreement enforceable by law. This discussion can be diagrammatically represented. Now, let us go to the mainstream topic, that is consideration. What is consideration? Section 2D of the Indian Contract Act 1872 defines consideration as when, at the desire of the promisor, the promise or any other person has done or obtained from doing, or does or abstains from doing, or promises to do or abstain from doing something, such an act or abstinence or promise is called consideration for the promise. An agreement must be supported by a lawful consideration on both the sides. Consideration is doing or not doing something which the promisor desires to be done or not done. These are few important aspects of the consideration. Consideration must be at the desire of the promisor. Consideration may move from one person to any other person. Consideration may be past, present or future. Consideration should be real, though not adequate. Further, let us study the explanation for the points explained. In most cases, the promisor for doing an act or not doing an act derives some benefit by way of consideration. Thus, consideration is identified as quid pro quo from the promise or performance of the promisor. But it is also possible that there may not be any identifiable benefit towards consideration. For example, A promises to carry B's goods free of charge and B allows A to carry the same. Here, B does not offer any consideration to A. Is this a valid contract? The answer to the question is B has suffered detriment or disadvantage while allowing A to carry his goods. Here, there is sufficient consideration. This illustration is given essentially to prove the point that consideration could not be necessarily a gain or advantage to the promisor, but it can even be a loss or detriment to the promisee. That is why consideration is referred to a concept with double aspect. It can often be seen that consideration is mutual. For instance, if A promises to sell his house to B for 5 lakhs, here A is the promisor and B is the promisee. In the same transaction, where B agrees to buy the house for 5 lakhs, B will be the promisor and A will be the promisee. Here, A must part with the house, B must part with 5 lakhs. This proves the point. The consideration is mutual and has 2 sides. Thus, it can be concluded that consideration is promise or performance that parties exchange with each other. A form of consideration is equal to some benefit, right or profit to one party or some detriment, loss or forbearance to the other. Moving ahead, let us study the legal requirements of a valid consideration. The first one, consideration must move at the desire of the promisor, either from the promisee or some other third party. But consideration cannot move at the desire of a third party. Example, where collector had passed an order that anyone using the market constructed by the zamindar for the purpose of selling his goods should pay commission to the zamindar. It was held that it was not a proper order, as the desire to receive consideration had not emanated from the zamindar but from a third party, namely the collector. Consideration can flow either from the promisee or any other person. The consideration for a contract can move either from the promisee or from any other person. This point is made clear even by the definition of the word consideration, according to which, at the desire of the promisor, the promisee or any other person doing something is consideration. That the consideration can legitimately move from third party is an accepted principle of law in India. Example, A by a deed of gift made over certain property to her daughter D, with condition that her brother B should be paid annuity by D. On the same day, D executed a document agreeing to pay annuity accordingly, but declined to pay after some time. B sued D. It was contended on behalf of D that there was no consideration from B and hence there was no valid contract. This plea was rejected on the ground that the consideration did flow from B's sister A to D, and such consideration from third party is sufficient to enforce the promise of D to pay annuity to A's brother B. Third point, executed and executory consideration. Where consideration consists of performance, it is called executed consideration. Where it consists only of a promise, it is executory. For example, where A pays 5,000 to B, requesting B to deliver certain quantity of rice, to which B agrees, then here consideration for B is executed by A, as he has already paid 5,000, whereas B's promise is executory as he is yet to deliver the rice. Past consideration. The next issue is whether past consideration can be treated as consideration at all. This is because consideration is given and accepted along with the promise concurrently. However, the Act recognizes past consideration as consideration when it uses the expression in the section 2D, has done or abstained from doing something. But in the event of services being rendered in the past at the request or desire of the promisor, the subsequent promise is regarded as an admission that the past consideration was not gratuitous. The plaintiff rendered services to the defendant at his desire during his minority. He also continued to render the same services after the defendant attained majority. It was held to be good consideration for a subsequent express promise by the defendant to pay an annuity to the plaintiff, but it was admitted that if the services had not been rendered at the desire of the defendant, it would be hit by section 25 of the Act. Now, adequacy of consideration. Consideration need not necessarily be of the same value as of the promise for which it is exchanged, but it can be something which can be inadequate as well. Inadequate consideration would not invalidate an agreement, but such inadequate consideration could be taken into account by the court in deciding whether the consent of the promisor was freely given or not. In Chijitumal versus Rampal Singh Air, 1968, the Supreme Court reiterated that consideration need not be material and may be even absent. In the said case, the father had died, leaving his house to two sons. They had agreed to partition the house, which did not admit the division in exactly equal parts, and one of the sons had agreed not to construct a door at a certain place in his portion of the house. In a dispute, the agreement was challenged on the ground that it was without adequate consideration. The Supreme Court came to the conclusion that the motive for the said agreement at the time when it was made was to avoid any dispute in future, and held that it was sufficient consideration. Next, performance of what one is legally bound to perform. The performance of an act by a person what he is legally bound to perform, the same cannot be consideration for a contract. Hence, a promise to pay money to a witness is void, for it is without any consideration. Hence, such a contract is void for want of consideration. Similarly, an agreement by a client to pay to his counsel a certain sum over and above the fee in the event of success of the case would be void, since it is without consideration. Consideration must not be unlawful, immoral, or opposed to public policy. Now, let us study validity of an agreement without consideration, or we can say what are the exceptions to the rule, no consideration, no contract. We have all along learnt that an agreement without consideration is void. Not only that, even inadequate consideration would render the enforceability of the contract quite difficult, as the free consent of the parties would become suspect. The Act, however, contains certain exceptions to this important rule. These are: first one, on account of natural love and affection. A written and registered agreement made between parties out of natural love and affection does not require consideration. Such an agreement is enforceable even without consideration. Second, compensation paid for the past voluntary services. A promise to compensate wholly or in part for past voluntary services rendered by someone to the promisor does not require consideration for being enforced. However, the past services must have been rendered voluntarily to the promisor. Further, the promisor must have been in existence at that time and he must have intended to compensate. Third one, promise to pay debts barred by limitation. Where there is a promise in writing to pay a debt which was barred by limitation is valid even without consideration. Creation of agency. In terms of section 185 of the Act, no consideration is necessary to create an agency. Next one, in case of completed gifts, no consideration is necessary. This is clear from the explanation to section 25 of the Act, which provides that nothing in this section shall affect the validity as between donor and donee of any gift actually made. Now, let us study the term lawful object and consideration. Let us discuss two other important ingredients of a valid contract, namely lawful object and lawful consideration. Speaking generally, all persons enjoy freedom for entering into contracts of their own choice, but this contractual freedom or their right to enter into agreements is not absolute. There is a limitation on such contractual freedom as they are bound by certain general provisions of law. This observation can be illustrated with the example. Suppose A agrees to pay ₹100 to B on B stealing C's purse, then no court can compel E to pay B even if he manages to steal C's purse, because it would amount to encouraging these things. While on the subject of object and consideration, it must be said that in practice it is difficult to distinguish between object and consideration, especially when consideration consists of a promise to do or not to do something. Sometimes both object and consideration are seen for evaluation. For example, where A agrees to sell goods to B, who is insolvent, and B assigns the benefit of the contract for ₹100 with a view to defrauding creditors. The consideration for the assignment, that is ₹100, is lawful, but the object, namely defrauding creditors, is unlawful as it is to defeat the provision of the insolvency law. Although object and consideration are sometimes intertwined, we have to, wherever it is possible, separate them and identify whether they are lawful or not. Now, unlawful consideration. Let us consider circumstances which would make consideration and the object as well unlawful. There are 7 such circumstances, namely, first one, agreement forbidden by law. Acts forbidden by law means acts that are punishable under any statute or rules or regulations made under any statute. For instance, a plantation company that is commenced for growing, felling and selling timber cannot enter into agreement to grow and fell sandalwood trees, as felling of sandalwood is prohibited by law with the Forest Act. Consideration defeats the provision of law, where an agreement is entered into with the object of defeating any provision of law, then it is prohibited. Law here should mean any statute, law, regulation, etc. which is in force. This can be illustrated with the example. An agreement by a Hindu to give his son in adoption in consideration of annual allowance to natural parents would be in violation of Hindu law, and hence it is unlawful. Any agreement by a Muslim with the wife before their marriage that the wife shall be at liberty to live with her parents after marriage is void, as it would defeat the provisions of Muslim law. Consideration that would defeat any rule for the time being in force. This is a situation not very different from the point discussed before. This issue covered with the point can be explained with the example. A will must be proved in order to be probated by a court. A mere consent of parties by way of agreement to accept this requirement of proof of genuineness or proper execution of will is not lawful and therefore cannot be enforced under CPC, where consideration is a fraud. There is an example to prove where the object or consideration of an agreement is unlawful on the ground of fraud. A and B are partners in a firm. They agree to defraud a government department by submitting a tender in the individual name and not in the firm name. This agreement is void as it is a fraud on the government department. Now, where object or consideration is unlawful because it involves or causes injury to a person or loss of property. The term injury means criminal or wrongful harm. This illustration where the object or consideration is unlawful as it involves injury either to a person or a property. A agrees to buy a property from B. Although A knows B had agreed previously to sell the property to Mr. C. The intention of A here is to cause injury to the property of C. Now, where consideration is immoral, this is the illustration where the agreement is void because the object or consideration is unlawful, being immoral. Where A agrees to let his house to a prostitute on rent, where with A's knowledge she carries on her vocation. A cannot collect the rent as the agreement is void, the object being void. Where consideration is opposed to public policy, agreement either because of their object or consideration being opposed to public policy are void and not enforceable. Therefore, the meaning of the expression public policy is very important. It can be interpreted in a narrow sense or in a broad sense. If it is understood in a narrow sense, it would cut into the rights of people to enter into even genuine agreements. Public policy as a concept is evolved basically to develop an orderly society and for the good of the community. But framing public policy itself is a difficult exercise, since a too restrictive approach would stifle the rights of people and a too liberal approach would open the gate for many illegal transactions. Therefore, policy on public policy has to be developed with circumspection. Public policy has been described as an unruly horse which, if not properly bridled, may carry its rider he knows not where. Time immemorial, the activities that I am going to explain next have been identified as opposed to public policy. The first one is trading with an enemy. Second, stifling prosecution. Third, maintenance and Champerty. Fourth, interference with course of law and justice. Fifth, a marriage brokerage contract. Sixth, interest against obligation. Seventh, sale of public offices. Eighth, agreement for the creation of monopolies. Ninth, agreement in restraint of marriage. 10th, agreement in restraint of trade. 11th, agreement in restraint of legal proceedings. So dear students, here we come to the end of the session. In today's session, we covered the topic consideration as per the Indian Contract Act. We also covered the topic of essentials of a valid consideration. Then we studied the exceptions to the rule, no consideration, no contract, and finally we also studied what is a lawful object, lawful consideration, and some aspects of unlawful consideration. Hope the topic has been really clear to you. Thank you so much. Have a blessed day. Thank you.